In terms of the bankruptcy, what it does is it provides them an avenue of getting a little bit of relief from potential creditors as well as legal action such as lawsuits. It doesn't mean that they're not going to be responsible, but it does mean that they now have time on their hands so that they can organize themselves well. So, for example, it gives them the opportunity to, through the bankruptcy laws, prioritize which creditors get paid first and how, and be able to negotiate for those creditors on who will get paid first and the priority system. So from a point of view of the ratepayer, I believe my concerns would be that if PG&E has to pay additional fines or restitution in some sort, that's definitely going to affect the cost of their electricity because PG&E is a regulated utility. So their revenues and costs are basically set up to be a fixed return. And fixed return isn't quite the right word, but it's a regulated return. And so if their costs go up because of a lawsuit, for example, then that cost gets transferred on to the ratepayer.
What about those who are looking for payments coming out of these fires? There have been stories now that PG&E is entering the bankruptcy process. Not only are they focused on things like the Camp Fire, which was the deadly fire of 2018, but there were other fires, say from 2017 and others, where they have stopped paying as well. What's the future like for those who are trying to recoup some of those losses?
This is a good question because the question becomes under the bankruptcy court whether or not the person receiving payment or the person who has a claim against PG&E is considered a secured or unsecured creditor. The secured creditors have first priority in a bankruptcy, followed by the unsecured creditors. Now, there are some laws regarding where legal claims fall in the bankruptcy proceedings. So in that regard, typically in legal proceedings, I cannot comment on California law, but generally speaking, there's usually a reasonable, if you will, or fair compensation that occurs if there's a lien or a hold based on a lawsuit. So I cannot, again, because I'm not an expert in California law, I can't tell you what that looks like in terms of the bankruptcy courts. But generally speaking, I don't think bankruptcy will stop PG&E from paying out any sort of claims that have occurred from this or will occur from this, but I think it will give them the time to organize themselves and to prepare, if you will, so that they can manage and best take care of their creditors.
As we move forward here with utilities that serve large portions of utilities, some monopoly areas affiliated with the government or not, as we move forward here, what are the reservations that people may have on incidents like this moving forward?
I think this is a fair time for the state of California to really consider where they go from here. And here's my thought, if you will. The fires, because of the population of the state of California and the density of the population in the state of California, when a forest fire does occur, there's a reasonable probability that it's going to affect a large number of people. And so the questions then become, first off, does the state do anything to change the way that they manage how electrical lines and forests interact with each other? Do they change how the right-of-ways are cleared, or do they do things that change the way that the power lines are established? One of the keys is there has to be fuel for a fire to occur, and so you clean out larger space around the utility line so that there's less fuel available, or do you do other things? If nothing happens, or if none of the policies or rules change, then the utilities may need to consider whether or not they start keeping a reserve fund for instances like this so that they basically self-insure against when a forest fire occurs because of an electrical accident. So these are going to be some things moving forward that I think are going to have to be considered and addressed if this is a continuing trend.